G'day, I'm Stephen Page from Page Private and Family Infertility Lawyers in Brisbane, and you're watching and listening to the Australian Family Infertility Law Podcast. This video is about my wish list for international surrogacy reform. Back in 2011, I was at a conference in Las Vegas, of all places, and I had a conversation with the then chair of the AIT committee of the American Bar Association, a lawyer from Minnesota called Steve Snyder. And Steve told me that there was a proposal by the Hague, so that's the Hague Conference on Private International Law, to have a convention regulating international surrogacy arrangements. The attraction of such a convention is obvious. He then said that there had been some suggestion, and it wasn't by the Hague, but it was by others, that the form of that convention should be along the lines of the 1993 Hague Intercountry Adoption Convention. Well, I exploded. I thought that the 1993 Hague Intercountry Surrogacy Convention was great in theory, but if the Australian experience was right, it was rigid, costly, slow, painful, and if the world did that with surrogacy, it was a mistake. That what the world needed was a convention that recognised the parentage of children and was administratively flexible and quick, simple, and cheap. Didn't mean that there should be toleration of exploitation, but it certainly meant that the priority should be as to the parentage of the child, that there was some certainty about parentage, which at the moment there just isn't. To my amazement, I was then asked by Steve and accepted to be in charge of that process. And from then until 2016, worked intensely with an attorney from Boston, Bruce Hale, and others, including Steve and Dean Hutchinson and Rich Vaughan, who also became chairs of that committee in due course, to write such policy. And that policy was accepted by the Parliament of the American Bar Association, their House of Delegates, on behalf of the over 400,000 members of that association. Sadly, there has not been such a convention put in place. I worked closely for many years with a colleague from England, Anne-Marie Hutchinson, about this. She was the representative for the International Academy of Family Lawyers on working groups at The Hague for this as an observer. And Anne-Marie said that the work on this convention will take a long time, and it's likely that the convention won't come into effect until after both she and I were gone. Sadly, she's been lost to us. My hope is that there is such a convention in place before I'm gone. Why has it taken so long to deal with such a convention? Well, the problem is fundamental. Europe, in general terms, does not like surrogacy, and European countries take parties, like the rest of the world, aside from the United States, to the International Convention on the Rights of the Child. Europe sees the surrogate is the mother, and therefore there is a fundamental problem about recognition of the parentage of the intended parents when they are not the parents. The United States, on the other hand, emphasises the right to reproduce. And this right has been recognised in limited ways in Europe by the European Court of Human Rights. But the Americans, having experienced eugenics, have made it quite plain that it is a fundamental right to reproduce. And this is reflected in their jurisprudence and simply just their way of thinking. So the United States stands as a beacon of light and hope about surrogacy. And we've seen 30 odd years ago, the California Supreme Court say that who are the parents are the intended parents, and then approach has been copied in other American countries, such as Mexico by its Supreme Court and Colombia by its Constitutional Court. There are worrying ways that surrogacy is done around the world, particularly in developing countries which don't have a legal framework and don't have a good human rights discourse. There really needs to be strong laws about surrogacy in each country, and they need to be framed in a human rights discourse. And by that I mean not only just the human rights of the surrogate and of the child, but also that of the intended parent. It's a balancing act. And this can be quite nuanced, and we've got to be quite careful about how that's approached. But as the California Court of Appeals said about 30 years ago concerning children born through surrogacy, these cases will not go away. Children continue to be born via surrogacy, whether the law of their country is good, bad, or indifferent. And parentage, therefore, of that child needs to be addressed. The child should not have the situation of limping parentage, where one of the two parents is not recognised at all, or the surrogate remains on the birth certificate, much like an albatross, still floating around, but not recognised by the child as a parent. So there really needs to be a priority of all the changes, the priority on ensuring that the child has parentage, that parentage of the child is secure. We've certainly seen the European Court of Human Rights say in a number of cases that if there is a particular type of order in the United States, for example, recognising someone as a parent based on intention through surrogacy, then they ought to be recognised as the parents. But that court has not been consistent, and there has not been a consistent approach internationally to recognition of parentage. Certainly, the approach taken by the UN Special Rapporteur on violence against women and girls, Ms. Reem Al-Salam, is not the approach to take. She has suggested that surrogacy be eradicated. Well, that won't work. The practical reality is the genie is out of the bottle. Somewhere, somehow, surrogacy will still happen. And eradicating surrogacy tramples on the human rights of the right to reproduce, recognised internationally, the right of LGBTQIA plus people like me to be able to reproduce, also recognised to the Yogyakarta principles, and the right of the child to an identity and the right to scientific progress. And anyway, I'll talk about these rights in another video about how surrogacy and human rights intersect. So as I said, it's nuanced, it's a new area, so it requires some development. But I hope that there is a Hague Convention to do with international surrogacy, that the parentage of children is secure, that these children's reality is not divorced from what the documents say are their parents. And when I say children, we have children now who are adults born through international surrogacy, where their parentage does not reflect that reality. I hope that there is a change internationally to change that, and so the parentage of these children is secure and their identity is secure. Thank you for watching and listening. I'm Stephen Page from Page Private Family and Fertility Lawyers in Brisbane, and this is the Australian Family and Fertility Law Podcast.